Hey guys, and welcome to the Working Money Channel. So here it is, guys, the latest breaking news from James K. Filan. Breaking: Judge Torres issues a ruling on parties' motions to preclude expert testimony. We're going to get into this today. We're going to get, several opinions from the XRP lawyers in the community, some other thoughts with regards to what is going on here, the good, the bad, the ugly. And I gotta say, the topic of the video I did yesterday morning, some in the XRP community were wondering if Judge Torres could in fact be compromised because of the Epstein verdict, if she was controlled by the powers that be. And I had a bit of a theory there, which was a complete 180 to what some in the XRP community were in fact stating. Well, I guess it looks like she is not, at least not yet, but we still don't have a final verdict. So guys, we are going to get into this today. XRP price, I guess there has been kind of a move for XRP price. I don't know if it is being reflected in the news that we are recently getting. We did see XRP pop about 1.5%. Nothing to write home about. Yesterday was trading in and around 36 cents. Now it's trading in around 37. So a 1 cent difference. But we are seeing XRP movement. We compare this to, the same time frame. By the way, that was XRP on the hourly. Compare that to the same time frame where we're looking at Bitcoin here, and Bitcoin, still relatively flat. Usually what we tend to see is Bitcoin moving first, and usually XRP is the one that is remaining flat. However, we are seeing some excitement for XRP. Of course, this is likely because of the positive news that we are hearing from the court. I guess I should say Bitcoin is right now trading at $22,300. Again, just trading sideways, and has been since earlier this month. And XRP right now, although it is up a bit, still not trading hands at exorbitant prices. It is right now trading at about 37.1. But we can see on the hourly, we can see it already popping a little bit now as of the time of this recording. So who knows where it will be by the end of the day. So we've got this brand new Judge Torres testimony, courtesy of James K. Filan here. Plaintiff and Securities Exchange brings the actions against defendant Ripple Labs and two of its senior leaders, Brad Garlinghouse and Chris Larson, alleging that defendants engaged in unlawful offer and sales of securities in violation of the Section 5 of the Securities Act. As we all know, before the courts, the parties' motions to preclude expert testimony from consideration at summary judgment and trial. So the summary is down in here. This gives some legal and factual background. I will link this entire link in the description, along with James K. Filan's tweet, which also links to this. To give you guys a basic summary, though, of what is going on here from JV the Great on Twitter, experts, the SEC, are trying to exclude on Ripple's side something that pops out to me. Over 1,700 XRP contracts by Ripple, with one category being counterparties agreeing to sell XRP on behalf of Ripple. So some of the defendants' experts in here, the SEC moves to exclude the testimony of Alan Schwartz, Peter Adrians, Bradley Borden, Peter Easton, Yisha Yadav, Alan Farrell, M. Laurentius, Murray, and Christina Champagne. CEDO bear motions. The SEC also moves to exclude the opening report of Carol Osler and the testimony in part of Danielle Fischel. So then it gives some detail on that. Again, that will be included in the 57-page brief. But some interesting points here, guys. Another one granted and denied in part highlighted how the SEC once argued that Howey doesn't require the existence of a contract. Schwartz can testify how Ripple's contract differs from securities contracts, but can't testify on the legal reasoning of Howey. I wonder why not. Next up, a win for Ripple's XRP expert Peter Adrian. The court finds the commercial utility and use cases relevant to the Howey test. So check this out. Third opinion. The court rejects the SEC's arguments that Adrian's third opinion about the commercial utility of XRP should be excluded because it is irrelevant and unsupported. Rather, defendants merely contend that the uses of XRP are relevant to the inquiry, and the court agrees. Adrian's opinions on XRPs and the XRP ledger's uses need not be dispositive of the court legal issue in this case for the opinions to satisfy the low bar. So sounds to me like a win for Ripple there. The SEC got denied completely on the Ripple XRP expert. Bradley Borden brings his expertise in federal income tax. And so the quote goes as such: the SEC says whether XRP is a security under federal income tax law has nothing to do with whether it's a security under Howey, and the court disagrees with that. So down here, the court disagrees the bar for relevance is low, and Borden's testimony is specialized knowledge that will help the jury determine a fact at issue in the case. So sounds like a lot of positive outcomes here for Ripple. Under defendant's theory of the case, how XRP is classified under other legal and industry regimes is relevant to the question of whether XRP would ordinarily and commonly be considered a security in the commercial world. Down here, XRP functioning like a currency and is not ordinarily and commonly considered to be a security in the commercial world. So they also note that in the commercial world, not commonly known to be or not commonly, classified as a security. As we know, the rest of the world does not consider XRP a security. The United States is the only country that is contesting its status. So that's another great point there. Another complete denial for the SEC regarding ODL. So they go into on-demand liquidity here. ODL may actually be the savior. XRP, Ripple, and the SEC. The judge appears to value the utility of a commercial world. So check this out, guys. The SEC argues that the court should exclude Osler's opinion because a virtual currency is not a currency under the Securities Act. And even if XRP were a currency, even currencies can be sold as investment contracts. The court disagrees because Osler's testimony needs to be dispositive to be relevant. And as this court has stated, whether XRP functions like a virtual currency is relevant to defendants' core argument that XRP is not ordinarily and commonly considered to be a security in the commercial world. This is just not looking good for the SEC. Ripple's experts aren't being restricted at all, at least when it comes to some key points. The judge is also allowing Ripple's experts to rebuttal some of the SEC's experts on certain components. So we got some more testimony with regards to that. And here they are. Expert number 5's event study methodology does not demonstrate that XRP holders profit solely or primarily from the efforts of Ripple. Another one from number 5 misrepresents his own findings by failing to recognize that many of the announcements that he finds to be statistically significant are confounded. Another one fails to appreciate the significance of his own admission that XRP did not trade in an efficient market. And finally, fails to provide any explanation as to why his event study would shed any light on whether XRP holders are engaged in a common enterprise with Ripple. Accordingly, the SEC's motion to preclude Fischel from testifying as to his first and fourth opinion is granted. So sounds like a win here, one win for the SEC, but this is a bit of a tug of war. The judge is not going to grant all of Ripple's motions, and the judge is not going to grant all the SEC's motions. It's going to be a matter of who is able to obtain more for their side's argument. JV continues, damn, the SEC's motion got denied as moot. They tried to get Champagnier, a Ripple XRP expert, rebuttal report about reasonable XRP purchases excluded, but it didn't sound like that went well. In conclusion, this is what we finally got, guys, from the report. Defendant's motions to preclude expert number 1 from testifying is granted as to his first opinion about the perceptions of a reasonable XRP purchaser and denied as to the remainder of his testimony. So the defendants are Ripple, and they were able to preclude expert number 1's motions, at least in part. So defendants' motions, Ripple's motions, to preclude expert number 2 from testifying is granted as his fourth opinion about the materiality of Ripple's potential disclosures and denied as to the remainder of his testimony. Defendant's motion to preclude expert number 3 was denied. Defendant's motions to preclude expert number 4 was granted as to his third opinion about the risks to the XRP ledger that might materialize if Ripple walked away or disappeared, and denied as to the remainder of his testimony. Ripple's motion to preclude expert number 5 from testifying is granted as well to his opinion on causation and denied to the remainder of his testimony. We've got the SEC's motion to preclude Schwartz from testifying is granted, so David Schwartz not allowed to testify with regards to his opinion on the Supreme Court's legal reasoning of Howey, and denied to the remainder of his testimony. So David Schwartz cannot talk, about legal issues, at least in the eyes of the court. The SEC's motion to preclude Adrian from testifying is granted as to his first and second narrative opinions and denied as to the remainder of his testimony. The SEC to preclude Borden is denied. The SEC's motion to preclude Eason from testifying is granted to his rebuttal report, but denied for his opening report. The SEC's motion to preclude Yadev from testifying is granted as to her third opinion about where an offer or sale of XRP occurs, and denied as to the remainder of her testimony. I'm almost done, guys. The SEC's motion to preclude Farrell from testifying is granted as to his legal opinions, including his second and fifth opinions in his opening report and portions of the rebuttal report, and denied for the remainder of the testimony. So it sounds as though, the judge really kind of cherry picking what is going to be granted and what is going to be denied based on these particular actors' specialties. The SEC's motion to preclude Osler is denied completely. The SEC's motion to preclude Fischel from testifying as to his fifth and fourth opinion is granted. The SEC's motion to preclude Marais is denied, and the SEC's motion to preclude Champagnier is denied as well. So it sounds as though the SEC lost this battle, more denials than Ripple. And so here we have John Deaton highlighting some of the main ones, the ones that are really, really important here. Ripple's motion to exclude expert number 1 from testifying is granted as to his first opinion about the perception of a reasonable XRP purchaser and denied as to the remainder of the testimony. He says, now try and tell me XRP holders don't make a difference. He reiterates defendant's motions to preclude number 4 from testifying is granted as to his third opinion about the risks of the XRP ledger that might materialize if Ripple walked away or disappeared, and denied as to the remainder of his testimony. So what does this mean, guys? It means that the over 50 affidavits we submitted from independent developers on the XRP ledger, like Spend the Bits, probably didn't hurt to show that the XRP ledger could survive without Ripple. So the judge is learning, the judge is getting it, realizing that Ripple does not need to be part of this, therefore solidifying Ripple's argument. Eleanor Turret here making a comment. Judge grants Ripple's motion to exclude expert witness, which is expert witness number 1, which was Patrick Doody, from testifying about the perceptions of a reasonable XRP purchase. Guys, this was a big one. If you guys remember, I did do a video on this months ago now. I'll see if I can find it and we can link it up here. The Doody controversy was a big part of this at that time. I'm trying not to make this video too long, so I'm going to keep moving along because we got a lot of information here, a lot of opinions. Crypto Cowboy here, if she's going to rule in Ripple's favor, you can see where she's almost setting it up to say they don't have any evidence of believing expectation of profits, and the expert they do have doesn't bring a lot to the table. If that's the case, you got to be happy if you are Ripple. And Mikkel did host a Twitter Spaces last night. Huge lineup in the Twitter Spaces, including Jeremy Hogan, Fred Rispoli, Bill Morgan, and many others in the XRP community. Listen to what Jeremy Hogan has to say here.
Thinking that last prong is where she's going to hang her hat. If she's going to rule in Ripple's favor, you could see where she's almost setting it up to say, well, they don't have any evidence of a reasonable expectation of profits, and the expert that they do have doesn't really bring a lot to the table, and therefore no reasonable jury could find against Ripple, since the SEC has the burden of proof. And so you could kind of see so it could be either way. I'm not saying that it's not going to trial, but she could also be setting it up for a summary judgment ruling. And if that's the case, you got to be pretty happy if you're Ripple right now.
So as Crypto Cowboy quoted up here, Jeremy Hogan essentially saying, setting it up, not saying it will not go to trial, but, it's very good for Ripple. They have been able to prove quite a lot. So wanted to thank Crypto Cowboy just for, putting up this clip, and obviously to Mikkel as well, just for hosting that Spaces last night. Unfortunately, I was not able to attend. Eleanor Turret here with another tweet. It's worth noting that the SEC lawyers tried to get Judge Torres to ban John Deaton from participating in the case, partly because he disclosed the name of their expert witness. Not only did she not ban him, she agreed with him that Doody shouldn't testify about XRP hodlers. And if you guys didn't catch that video that I recently said that I was going to link up here, I do suggest you watch it. That was the big controversy. I almost want to think that this was from early 22 or maybe even late 2021. I think he was also getting harassed by the XRP community at some point. If my memory serves me correctly, that is what we were contending with at that time. Anyway, now the facts are in. She agreed Doody should not be testifying about XRP hodlers. Gonna keep moving because we got lots of opinions here, like from Bill Morgan. The Australian XRP lawyer, I thought when I read the Dober motion that it wasn't such a great sign if most of Ripple's expert testimony survived. Most of it did survive. So what does that mean? I'm glad to see most of Alan Schwartz's report is admissible. It is relevant to the Blue Sky issue, as Judge Torres said. So excuse me, when I was mentioning the summary there, I was saying that it was David Schwartz's testimony. I guess it was Alan Schwartz's testimony that was not admissible because he did not, at least in the judge's eyes, did not have expertise on that particular matter. So as Judge Torres said at page 29, how to interpret the Supreme Court's reasoning in Howey is the central question in issue to this case. Schwartz is permitted to testify about Ripple's contracts and how they differ from the Howey contracts. That is important. Further, though, the judge accepted that the contracts and their provisions are relevant to the issue whether an investment contract exists. She found that Schwartz's evidence is relevant to this analysis. I was also heartened that the judge accepts on page 33 that XRP having a use is relevant to the inquiry as to the third prong of Howey. I thought Adrian's opinion on the issue, which the judge allowed, was more important than the two opinions she denied. So again, not a clear out win, not a clear out loss. But again, to use the same analogy, a bit of a tug of war. Where does the judge see more legitimacy in which arguments? And it sounds as though that is on Ripple's side. Moon Lambo down here asking, why would it be bad if most of Ripple's expert testimony survived? And that's the same thing I was wondering. Or did you mean that it would be bad if most of Ripple's expert testimony didn't survive? Or maybe I'm misunderstanding you. If so, my apologies. Bill Morgan responding here, I meant not a great sign for the SEC. So that's good. They really wanted and needed to strike a lot of it out, and clearly they were not able to. So wanted to thank Bill here for chiming in, giving his 2 cents on this legal decision. We got Jeremy Hogan here as well. The SEC has to prove that you had a reasonable expectation of profits from Ripple's efforts, and the judge just struck the SEC's only expert witness on the subject. So going back to the expert witnesses and the SEC's expert witness specifically. So now, how the heck can the SEC prove reasonable reliance? Who will testify? And I've got a question. Can they now, I'm assuming they probably cannot, but could they get another expert witness in late? I doubt they can. Jeremy Hogan here saying, just thinking out loud. Responding with a second tweet here, well, I hate to answer my own question, but apparently the judge thinks that expert number 3's opinions as to Ripple's incentives and actions to influence XRP price is relevant to the issue of reasonable expectations of profit. So that doesn't sound so good. However, Jeremy Hogan quantifying that with, they're saying this, but, and I quote, seems fairly weak sauce to me, which means he doesn't see this as a strong argument at all. So we got some insight here from Jeremy Hogan, and Bill also just picking up on that last Jeremy Hogan tweet with regards to the judge thinking that expert number 3's opinion as to Ripple's incentives and actions to influence XRP price is relevant to the issue of reasonable expectation of profits. He says the SEC made allegations in its summary judgment motion of at least 6 actions that I can recall which Ripple took to support or increase XRP price. Those are how he steps on the SEC's case theory. Although whether they made much a difference or announcements of them made much a difference to XRP price is an issue in dispute, and the SEC is weaker on that because the judge didn't allow Dr. Metz's opinion that Ripple's announcements caused XRP's price to rise. So a positive point there in the Ripple column. So guys, I think what's on everybody's mind now, the next question that I think we're all asking ourselves, where do we land from here? How much more time until we get this final verdict? And again, you know, there's still a lot going on. However, we are getting very, very close to a final decision. Even Fred Rispoli here saying 57-page order from Judge Torres on the SEC and Ripple's motions regarding expert testimony from Filing Law incoming. This is not the SEC ruling, but this means the SEC ruling is very, very close. XRP Princess down here asking, not holding you to it. But what do you mean, Fred? A day, a week? Expectations, not holding you to it. Just want to know where your head is at. And Fred Rispoli responding down here, I would say this month. So guys, it looks like we're still on track for a March 30th. Hopefully March 30th by the latest. James Filan suggested we'd see a likely simultaneous ruling on experts and summary judgment, and that made a lot of sense. So summary judgment is either coming out at any moment, or Judge Torres is dropping this one first to cajole the parties into settlement at the last chance. So possibly a strategic tactic by Judge Torres to, as Fred Rispoli saying, to cajole the parties to, maybe convince them to come to a settlement agreement so that this does not have to go to trial. I mean, we don't really know what's going on in the SEC's head. We don't know what's going on in Ripple's lawyers' heads, although what we do know is that they're not giving up the security verdict. If XRP is deemed a security, there's no way they're going to settle. We've heard that from Stuart Alderati in the past. But this could be one last-ditch effort, giving us, the latest verdict here. We're seeing Ripple having more leverage, I think, now for negotiation powers. So now it's just going to be a matter of where the SEC wants to land with this, I think. We've got British Miss up here also asking, heavyweights believe a summary judgment is expected by the end of March based on the judge's latest moves. I cannot believe it is almost over. So we got Fred Rispoli saying this, saying basically Judge Torres perhaps trying to convince both sides to, come to a final conclusion, come to a final settlement agreement so that this doesn't have to go to trial because that would just drag it on a whole lot more. We've also got John Deaton, of course, on the heels of this tweet thread. Dr. Giggles here was asking, thanks, John Deaton. Does this give any suggestion or hint on the remaining time till summary judgment? And John Dean did respond, I seriously doubt that we see a significant delay from here. Could be tonight or in a couple of weeks. Well, I think we would have heard it if it was March 6th, the evening of March 6th. I don't think we got any more information other than, the information that we've already gone over. And so also thought I had a response from Jeremy Hogan, but doesn't look like he has given a timeline. I do think, though, in a previous video, he did say that he is still agreeing with James K. Filan. A March 30th deadline. I'm assuming John Deaton's 2 months from now, more recent time frame, has gone out the window. Considering we have now gotten this new information, it's still a tug of war, guys, but looks like Ripple is winning. That's just my opinion, but I want to hear what you guys think. Please subscribe to the channel if you haven't already. Like the video if you like the content I'm providing. I always love hearing your comments. See you in the next one, guys.